Ladies and gentlemen, my name is Tom Harley and I'm Chairman of the Menzies Research Centre. And on behalf of my fellow directors, Tony McClellan, Michael Osborne and Arthur Sinodinos and Julian Lisa, I want to welcome you to today's launch of Don't Leave Us with the Bill. I'll introduce General Cosgrove in a moment, but before I do, I want to acknowledge a number of people who are here today. I'd like to acknowledge a dear friend and a founding father of the Menzies Research Centre, Robert Hill, who has returned from New York and ceased to be a public servant yesterday, I think. I'd also like to acknowledge Gillian Skinner, the Deputy Leader of the Opposition, Greg Smith, the Shadow Attorney General, Andrew Laming, the member for Bowman, Jonathan O'Day, the member for Davidson, and my fellow members of the MRC board. I'd also particularly like to acknowledge the two editors, Julian Lisa and Ryan Hadrick. Would you like to stand up so people know what... While the MRC is associated with the Liberal Party, it seeks to tackle policy issues by bringing in ideas and perspectives from outside the Liberal Party. Julian and Ryan have excelled in this. The authors have managed to assemble one of the most diverse, distinguished, eclectic and ecumenical groups ever. A former Governor-General, a former Liberal Prime Minister, a former Labor Minister, two former High Court judges, I'm counting Sir Ninian twice, you see, one reigning Chief Justice, a former Solicitor General, plus a Major General and a Brigadier, two of Australia's most distinguished historians, a Cardinal from Ballarat, a Rabbi from Melbourne, and from Sydney's northern beaches, a Bishop. Why did the MRC tackle this issue? I think there are four reasons. The Rudd government has put it on the national agenda with Father Brennan's consultative group. There's always been a movement for a Bill of Rights, and I'd like to acknowledge former Senator Susan Ryan, who's chairing the Human Rights Act Committee. Is that the right designation, Sue? Welcome. But the Menzies Research Centre is named after Robert Menzies, and his thinking is something of a touchstone for us. And I'd like you to indulge me in a quote from Menzies. I'm glad that the draftsmen of the Australian Constitution, though they gave close and learned study to the American Constitution, made little or no attempt to define individual liberties. They knew that with legal definitions, words can become more important than ideas. They knew that to define human rights is either to limit them, for in the long run words must be given some meaning, or to express them so broadly that the discipline which is inherent in all government and ordered society becomes impossible. As I understand it, wrote Menzies, the Australian draftsman had good reason for not following the American model. In short, responsible government in a democracy is regarded by us as the ultimate guarantee of justice and individual rights. Except for our inheritance of British institutions and the principles of the common law, we have not felt the need for formality and definition. I would say, said Menzies, without hesitation that the rights of individuals in Australia are as adequately protected as they are in any other country in the world. In America, there is a long history of distrust of official people, as they are not directly answerable to Congress, where they do not sit and in whose proceedings they are outsiders. It has been thought necessary to impose constitutional limits upon them, with the Supreme Court as the interpreter of those limits. And as the interpretation of such provisions will be largely affected by political and social concepts, the judgments of the Supreme Court of the United States tend to possess a political flavour which is notably absent from the judgments of the High Court of Australia. R.G. Menzies' supplementary note on the absence of a Bill of Rights in the Central Power in the Australian Commonwealth, published in 1967. In my view, and a view articulated so well by the authors, this is a book about defending and promoting rights, liberty and democracy, from some who at times well-meant and muddled campaign for a bill that will threaten them and do real harm while seeking to do good. It is a singular achievement, and the Menzies Research Centre is very fortunate indeed to have Julian as its Executive Director. He, with Ryan, has managed to assemble, edit and publish this work. And at the same time, Julian has been working with Arthur Sinodinos on a major task force examining how Australia might leave the global financial crisis in an even stronger position relative to our competitor nations. He's also been working on 2 other books, one on Liberal women in Cabinet, written with Margaret Fitzherbert, and a second on state aid, which is in education, which is being written by Graham Starr. It's now my great privilege to introduce General Cosgrove. Some of you may wonder why we've invited a general, a military figure, to launch a book on a Bill of Rights. It's quite simple and it's clear. General Cosgrove led the most conspicuous single act by an Australian in returning rights and liberties to a people in the intervention in East Timor. It's with immense pride that I ask General Cosgrove to launch the book.
Thanks very much indeed, Tom, for that introduction, and indeed to the Research Centre for your kind invitation to me through Julian to launch Don't Leave Us with the Bill. Just before I make a start, a while ago in referring to ructions between the official level of the Department of Defence and the ministerial level, some reporter opined that it had been thus for years. There was a significant break when Robert Hill was there. Don't leave us with the Hill might have been what the journalists were implying, but I'm delighted to see Robert home. He was a wonderful steward of the portfolio, and I said so in my great work of fiction, my memoirs. And it doesn't need to be that ministers and the servants they have in their departments are automatically at daggers drawn. I've had the opportunity to launch many books over the last couple of years, maybe 10 or 15. Anthologies of poems, historical accounts, great works of drama and fiction masquerading as memoirs. But this is without doubt the most significant. Grasping, as it does, not touching upon, but grasping one of the most crucial issues of our time, not of the economy, domestic or global. Problems there pressing but ultimately solvable and transitory. Not of security, even though these issues can at times cause us the greatest dread and anguish. Instead, it is an issue which goes to the heart of our democratic conditioning, our expectations of the law, of our governments and of our judiciaries. Such a book is Don't Leave Us with the Bill. One of the reasons why, when commentators were opining of relationships of times past within the Department of Defence and between the Department and its ministry, that I remained silent was a bit of a convention that old CDFs are better to be seen but not heard, and not seen too often. So I just kept my peace as a member of the silent majority. In our lifetimes, a pundit coined that term, the silent majority. He didn't mean that the majority of which he wrote were in favour of this thing or that thing. I'm sure he meant that the majority was simply silent, a sort of vocal inertia, a retreat into the form guide of life, unless reluctantly enraged. In 1975, Gough Whitlam must have known, as he famously intoned, "Maintain your rage," that he had a couple of weeks at most before the Test cricket started and Christmas came around. Isn't it interesting that the Republic referendum gained our full public interest for longer than the dismissal and the replacement of a government? Now, I'll agree that the battle raged on in the esoteric levels of academia and politics and the commentariat, but not within the public. Now, in both of those seminal moments, the dismissal and the referendum republic, I remained a member of the silent majority for the obvious reasons. First, my duty, I was in uniform on both occasions, and my confidence in our system and the silent wisdom of the Australian people. Sometimes an unlearned, intuitive wisdom, but a great wisdom nonetheless. Such silence guides governments as much as does the occasional outburst of passionate reaction. Relative silence has so far characterised the renewed interest in an Australian Bill or Charter of Rights, and hereafter, for simplicity, I'll simply refer to it as a bill. For many Australians, we are comfortable that the national debate on high policy issues be evolved, fought out and decided at esoteric levels. For most of us, a quick read of the op-ed pages of our favourite broadsheet to provide us with a point of view to express at the water cooler suffices for our in-depth knowledge of arcane issues. Cautionary, arcane compared with the goings-on in our favourite football code. Referenda are somewhat different. We learn at our father's knee that the federal government would not ask for a decision through a referendum unless the matter involved was far-reaching and contentious. After a few false starts over the years, the notion of a Bill of Rights, now resurrected through the medium of the Brennan Review, is as important an issue, possibly more important as an issue than, say, the debate on the Republic. Yet until now, it has largely been an issue confined to the commentariat. Many Australians, not least many Victorians and Australian Capital Territorians, would be surprised to find that their jurisdictions were operating statutory bills of rights. It seems that unless a Bill of Rights is invoked relative to you, to your advantage or to your detriment, then it remains an obscure fabric, part of the great legal security blanket of our society, keeping us warm and safe and taken very much for granted. It probably takes a referendum in this country to properly get the public juices flowing. Republicanism did it for us just as the conscription referenda did in World War I. Something needs to do it for us for the Bill of Rights, or its mundanity might become its monstrosity. As by now a well-travelled person, I like our democracy. I've been to countries where their Bill of Rights have not made a jot of difference to the crushing inequities within their societies. Yet their diplomats and intelligentsia will froth on advising Australia of our shortcomings in this regard. Our forward scout in the United Nations, Robert Hill, can probably enumerate the lectures he's received on the subject. Australians are rightly suspicious of apparent Me Tooism. Profound and enduring laws ought not to be a fashion statement. Are these societies where bills of rights overarch the administration of law better places to live than Australia? Places where inequities are immediately prevented or immediately redressed? The founders of our federation left us with a constitution, but not a Bill of Rights. They wanted the elected government to make laws and for the judiciary to administer them. It seems they had intended for the constitution to be the only immutable, but the constitution itself was available for change, but only by an irrefutable majority. Perhaps they understood that a bill which sought to codify rights then would chafe badly on an evolving society. Immigration policies, social justice issues, particularly those involving Indigenous Australians, these and other important rights issues would have been differently treated in 1901. It seems that the founders expected that the elected governments of the day would do their job of responding to the contemporary needs and demands of the people, paying the usual price for inattention or error. That principle has brought us through many sea changes in social attitudes. The ideologies and policies of many governments in our federal system have been tried and exploited and discarded, along with the governments which have espoused them. Those elected governments, with their dynamic ability to create laws which may be contemporary and often transitory, are balanced by the longevity and narrowly profound expertise of the judiciary in interpreting and applying the laws made. Australians, perhaps intuitively, like and prefer this system. It allows us to respect and support the judiciary because they administer the laws of the land, laws they have been given. It allows us to pressure the governments to react with policies and laws to meet particular needs and demands within the boundaries of our Constitution. Our judges are not elected. They are good men and women for whom we have enormous respect. Although I once did hear a man in the dock of the Old Bailey use frightful language at a judge. And at least one of the SAS has joined them in the term unrepresentative swill. I'm sure he joked. By definition, they have an encyclopedic knowledge of the law and, over time, a profound knowledge of human nature, but in the particular. They live necessarily in a cloistered environment. Not too many High Court judges have had substantial second careers. We understand and approve of this notion of the cloistered judiciary. One of the features of a Bill of Rights is the interpretive role of the judiciary in comparing the generic indicative language of the bill with other legislation to produce an outcome. Judges may be empowered to read down, that is, to change the apparent effect of the other legislation to conform with their personal interpretation of the bill. Judges don't have the personal experience or the wider resources to comprehend the full gamut of policy issues involved in decisions which, often made in the particular, may have the broadest impact. Politicians in power have the advantage and the burden of the full range of bureaucratic advice, policy options and community pressure, all this before making law or policy for which he or she is directly and speedily accountable. Much has been made of the possible statute nature of an Australian Bill of Rights. In other words, the Parliament giveth and the Parliament taketh away. Even a mildly cynical review of the history of statutory bills of rights in other similar democracies shows that the overarching nature and the superficially appealing language of these makes it extremely hard for a government to roll it back in whole or part. I was interested and then fascinated when I read through Don't Leave Us With the Bill. It canvasses the history and the import of bills and charters of rights and comprehensively and persuasively argues against this course for Australia. The essayists, which include the editors, and compliments to you both, number some of the most well-known and respected members of our national community. The 25 essays, the foreword and the afterword, are not only fascinating, but an exhaustive treatment of a subject of seminal and immediate significance. It is a vital and timely contribution to a debate which needs to pass from chambers and common rooms to Speaker's Corner and the public bar. I commend Julian Lisa and Ryan Hadrick as editors and the Menzies Research for bringing the thoughts of the essayists to us in this way. And I thank the essayists on behalf of the Australian public for this powerful collective contribution. Before reading this publication, which I have the honour now to launch, like most Aussies, I was perplexed but vaguely worried about the prospect of a Bill of Rights for this nation. The rights to be described were unassailable. The probable language soothing, seductive even. The effect, though, would be sedative and insidious. Don't leave us with a bill.